Number 82, matter of Waite v. Town of Champion. Good afternoon, Counsel.
Afternoon. I would like to reserve 2 minutes for rebuttal.
You may, sir.
May it please the Court, my name is Brad Pinsky, and we represent the appellants in this matter. This Court has often recognized that words matter, and the legislature knew the difference between division and dissolution. The legislature used those words, division, in Towns Law 73 and 74, and the inescapable conclusion is that what happened here was a division.
Does the Town of Champion Fire Protection District, did that exist once they created the other two fire protection districts?
Of course it did, because
Have the same boundaries?
Yes, it previously was the entire town. It's still the entire town. Whether it's one
but the two districts have different boundaries, do they not?
The two districts encompass the entire town.
Yes, but they have different boundaries. Each one is different, is it not?
True, but let's look at what a fire protection...
And they contracted with different villages, did they not?
They were still in control, just as the town was still in control, just as it was when there was one fire protection
Of course,
district.
but did they contract with different villages?
They did contract with different fire departments. They got rid of their fire department who had been serving them for 100 years.
So then how is it a failure to dissolve within the statutory meaning?
Sure. How much time do we have?
Not much.
Let's look at first what the legislature intended. The legislature recognized when it passed the Citizens Empowerment Act that citizens have no right to cause the dissolution, at the end of the process, the dissolution of a local government entity. So they created the Citizens Empowerment Act. It would make no sense to...
Yes, but it seems here, I've got to stop you on the long
Sure.
road through the law. It seems here that they did follow technically what they needed to every step of the way. Your clients are dissatisfied. It strikes me that the law provides some recourse for them, which is to gain signatures to dissolve these two or create another fire, or create a fire district, but they weren't successful. It seems to me that the law and the system has worked as intended.
No, the law is working because we are here. What that petition process is only if the residents do not like the outcome. But the law permits 5 residents or more to petition when the local government is unable or unwilling to accomplish and complete. The legislature used the words accomplish and complete.
Isn't the, I'm sorry, Judge, go ahead.
At the end of the day, under the town law, the town has the right to make the decision after going through certain processes, for one thing. So my question is, and it's sort of the interplay between these two sets of laws, my question is let's assume you're right, okay, and what the town did was not permitted. And just keep in mind, too, I'm not sure what dissolution of a fire protection district that has no assets and no bills and all that stuff is. But anyway, let's assume that the town properly dissolved the fire protection district. So how long, so does that mean that never again, never, can the town create a new fire protection district the same or similar to the one that existed?
The legislature thought about that. So what happens in this law is the legislature recognizes that the existing local government entity cannot exist any longer. There were only certain available options, such as, but not that we demanded, a fire district or a joint fire district. The power to dissolve a joint fire district or a fire district lies with the district and no longer the town. So no, the town could not create a fire protection district because a fire district would be in its place.
Well, I'm not sure where the statute says that when you dissolve a fire protection district, then the end result must be a fire.
It doesn't say what it must be. It's clear what it cannot be, and it cannot be the exact same local government entity.
But that's the problem. It's not the same. There are two different districts. They're contracting with different villages to provide those fire services.
Let's look at a fire protection district. We must look at this. A fire protection district, Miller v. Savage, numerous cases at the appellate division level have recognized, quote, that a fire protection district has no independent existence from a town. The town is in control under 1402 of the Not-for-Profit Corporation Law, under 184 of the town law.
Who's in control of a fire district?
Fire district under 174, I believe, the town law, is a separate political subdivision of the state. 5 commissioners are in charge.
And how are the commissioners chosen?
It depends whether it's a fire district or a fire or a joint fire district, but
at the
generally
core
they're
of it,
elected every year.
They're elected. So the volunteer firemen on one hand are running the fire districts, and the town board is running the fire protection district. Is that a fair characterization?
It's fair to say that the town board is absolutely by law in control of a fire protection district, but the residents are in charge of a fire district because they're elected.
So, but isn't the core of your argument, and you can correct me if you think I'm wrong, is that in effect, dissolution didn't take place. What took place was division.
That's exactly right.
And so on this scenario that we have in front of us, which argues for a procedural compliance with the law, it is in fact an attempt to subvert the electoral process.
The town thumbed its nose at the voters and the legislature, and we would like to propose a bright line test so that this court, it's not in our brief, so if I may.
So how do we, you can get to your test, I do
thing.
want to hear it, but how do we look at what Judge Rivera said, which is that they've created a new fire protection district with different lines. It is not the same legal entity.
Of course it is. A fire protection district has no separate independent existence. The town is still in control of contracting. The town still sets the tax rate. The town still
Well,
chooses.
Okay, but if I have the town of Buffalo, New York, and it's 32 square miles, and I cut it in half and call it Buffalo 1 and Buffalo 2, then they're not the same thing, are they?
Because a town has a separate political existence. Again, look at a sewer district, a lighting district. A resident says, I don't want to live with the lights above me anymore. Cut it into 2, and they still live with the lights above them because it's under the control of the town. It's not a separate entity.
But doesn't the case really boil down to, because they have followed the technical requirements for dissolution. I understand your argument about division, but let's go to something else. Doesn't it boil down to your clients don't want a fire protection district, but doesn't the law, at least now as it stands, leave that choice about how best to provide fire services to the town? You have, your clients have their recourse through the electoral process. So far, they have not been successful. Maybe they will be in the future. But right now, the town made a choice that this is the best way to deliver these services that they must under the law deliver.
But they have to create a new local government entity within the bounds of the law. And let's be clear, the Fourth Department was
Right, and they did.
They did
and your
not.
clients may be unhappy with it, and they have their recourse under the law.
We disagree, because they never accomplished and completed dissolution. And if I may, I'd like to give this court, it was not in our brief, the test to determine. As we know, what happened when Article 17, when the...
Before you do that, how would you dissolve an entity such as this,
Yep.
as I said, that had no outstanding debts, no assets, no...
They had a contract. They had a 5-year, they had successive 1-year contracts had they had with the fire department.
Was the contract terminated?
The contract was terminated. It expired in the record, I believe, but
Okay.
it no longer existed.
So
So they
aside-
wound up that
Aside
contract.
from creating a completely different type of entity, what more could the town have done to dissolve the existing entity?
It's
We're
not just about
talking
this town.
What they do next.
Right.
What more could they have done with what already exists?
So under town law, town law 184, a town has the right to own equipment, own fire apparatus, own other assets as part of that. If this town had owned them, they would have wound up and had to sell
They
them.
didn't. But they
They didn't, but going forward in precedent, that's a non sequitur. They could have owned them.
But how can we tell whether it was dissolved if none of those things exist?
That's what I want to tell you. So what happened when the state legislature created the Citizen Empowerment Act, they repealed every single dissolution statute and took every single dissolution and consolidation statute and put it inside 17A. So here's what happens. We have a test for you. So if it deals with dissolution, it's inside 17A. If the ultimate formation of the new entity can be achieved outside 17A, it cannot constitute dissolution, right? Dissolution can only be accomplished inside. So here's the test, here's what happened. The town's plan could have been achieved by diminishing the boundaries outside 17A. Under 172C, they could have diminished the boundaries of the fire protection district, and then under Town Law 170, they could have formed a new fire protection district. That achieves the exact same goal. Thus, as a matter of law, it cannot constitute dissolution because all of the dissolution statutes were repealed and put into.
If they change the boundaries by an inch, that's enough, that'll take care
No,
of it?
that would be more gamesmanship. This court should not allow any
Under
municipal.
your scenario, they've changed the boundaries and now they've created a new one.
They changed the boundaries outside of 17A, which shows you that it's not dissolution. They would have to dissolve the entire government entity inside of 17A. If you can achieve it outside 17A, it can't, as a matter of law, constitute dissolution.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. Jonathan Fellows, Bond, Shenick and King for the town.
Counsel, before you start, just a quick question following up what Judge Stein said. I'm a little confused over exactly what was dissolved here. So the town had a fire protection district. They had a contract with an independent service to provide this fire protection?
Yes, Your Honor, there were contracts with 3 entities. 2 of them were village fire departments, the Village of West Carthage and the Village of Copenhagen. And the 3rd entity is the Champion Volunteer Fire Company.
Right, and that's the contract that then is dissolved with the Champion Volunteer?
Contract that was between the town on behalf of the Fire Protection District and the Champion Volunteer Fire Company has been terminated by the town on the grounds
this
of breach.
dissolution?
And there's a separate legal proceeding by the Volunteer Fire Company to challenge the termination of that contract. And, Your Honor, I think you go right to
Just
him.
before you get there, so then you split it into 2 fire protection districts, and those are with the 2 towns that you just mentioned you had contracts with before?
Villages, Judge.
Villages, I'm sorry, yeah. And that's
So
what exists now?
the Fire Protection District Number 1 has a contract with Copenhagen, Village of Copenhagen, and Fire Protection District Number 2 has a contract with the Village of West Carthage.
I see. Okay, thank
So
you.
did you have to split it at all to comply with the dissolution statute?
Well, yes, I believe we did, Judge, but that's what we did. So
No,
we
yeah, what I
created
guess what I'm
2
asking is, suppose you
new
had just
entities.
dissolved the existing one and created a new one that was exactly the same, one district, would that have complied?
No, Your Honor, I don't believe so.
Why? If you've gone through the same processes that you did go through, but it was just one district, why wouldn't that comply?
The point that appellant keeps making is everything is the same now as it was before. And, Your Honor, everything is not the same. If I lived in the Fire Protection District before this dissolution, I was taxed on the basis of the entire expense of providing fire protection in that district and payments to 2 departments in 1 company. And that's in the record what was paid before to those 2 village departments and 1 fire company, and I was taxed for that. Now, we've divided it. I live in Fire Protection District Number 2. I'm taxed on the cost of providing fire protection in that district alone.
Right, I get that what
we have-
happened is not my hypothetical, but I was still trying to get an answer to why, under my hypothetical, you think that would not comply with your obligations.
Well, Your Honor, technically, if you read through the statute, it would. I mean, the statute says, here's what a plan of dissolution must do. And Judge Stein's questions really go to a point of perhaps the legislature should have done more or less in terms of including fire protection districts, because they aren't really what they were after in this statute. What they were after was separate taxing entities that owned assets and had employees. And when you look at what must be in a plan of dissolution, Your Honor, it says, what are you doing with the employees? What are you doing with the assets?
What I'm confused about is, it seems to me that dissolution is one thing, okay? There's a process of dissolution, and whatever it was ends, and then the creation of something else is a completely separate process, okay? So my question is in this exact circumstance, how do you know that the old one was dissolved?
You know that because the town board on August 10th, 2015 passed a resolution dissolving it and approving a plan of dissolution. And that resolution's in the record.
But that wouldn't be enough if it had assets that needed to be sold or whatever, or, right?
If there were assets, that plan of dissolution would have had to resolve what's happening to those assets.
But it's enough here because there was nothing to do.
Correct. And, Your Honor, if I
Well,
may.
there
let
is
me- let
something
me
to
ask-
do. You've got to walk through the, as you say, there's a process. You followed all those procedures, including developing and adopting a plan, voting on the plan at town board, having public hearings about the plan, all of that. You put together a document that sets out all the requirements that the statute sets out, that you have to say whether or not there are liabilities, how you're going to wind down, and all of that. So it's, you are doing something, are you not?
Your Honor, we did a lot, and we followed the exact roadmap in Article 17A. But the point that my opponent respectfully, completely forgets is Article 17A was intended to ease the elimination of overlapping separate taxing entities. And what he's doing, and he said it again not today, is what this statute required was the creation of an overlapping taxing entity. There's nothing in Article 17A which says you must create a new overlapping taxing entity. There was no overlapping taxing entity before, and now he's saying because of this statute, you must create a fire protection district, which, as Judge Fahey noted, requires elections, commissioners, and typically in upstate New York, they're then controlled by the volunteer firefighters, and they can impose taxes to pay for their fire equipment. And that's not what the town board wanted to do. And the notion that the town board thumbed their nose at the results of the election is completely incorrect.
Well,
What the resolution...
Hold on a second, Mr. Fellows. So the problem is the logic of your solution to the dissolution. Let's take it two ways. First, you've got the statutory interpretation problem. And the statutory interpretation problem is, what is the meaning of dissolution? Dissolution is defined as a termination of the existence of a local government entity. You can rationally argue that that's what you did. So the only problem is you created two entities that duplicated geographically the exact same thing as the one you had before. The logic of what you're saying is that another dissolution, you could then go out and create 4 entities and do the same thing. In another dissolution, you could create 8. And that's the logic of what you're arguing. So then, if we're confronted with that absurd situation, because that would be a patently absurd situation, we got to say, what's this statutory construction? What's the meaning of the text here? And it seems the meaning of the text is that if you dissolve it, it's kind of absurd to think that you're not creating something, you don't recreate the thing you just dissolved. And that seems to be what you've done, even though you've distributed the contracts. And that's the core of their argument, the way I understand it.
Your Honor, but a fire protection district is nothing but typically a contractual relationship between a town and a village fire department or a volunteer fire company.
Right.
And we entered into new, different relationships that will have different costs to the taxpayers. And, Your Honor, what the voters voted was on a proposition of, shall the town of Champion Fire Protection District be dissolved? And they voted yes. They didn't say, and you will then create a separate fire district with taxing authority and separate commissioners. No one voted for that because it wasn't on the referendum. What was left? When Article 17A was adopted, the legislature repealed certain provisions of the town law. They did not repeal sections 170 and 171, which govern the creation of fire districts and fire protection districts and alarm districts. And so that's still in place.
So if they're
And
dissatisfied, am I correct as to what their options are?
under section
The options
171,
being the residents of the town.
Your Honor, under section 171, they can submit a petition to require the town board to hold a public hearing on whether a fire district is appropriate. And that's their remedy. And
And ultimately, that is vested in the town to decide yes or no. And am I right that there is a pending Article 78 to challenge the creation of the 2 districts, or am I making that up?
no, that's what this proceeding is, Judge, in my mind. There is a separate challenge when the town board voted to terminate the contract between the town on behalf of the Fire Protection District, the old Fire Protection District, and the Champion Volunteer Fire Company. That was challenged in Article 78, which was then converted to a breach of contract action. I believe on the first page of our brief, Judge, we say what the status of that litigation is.
Counsel, do you know if the tax implications for this, positive, negative, neutral, in terms of what was paid before by the residents and what's paid after?
We believe it'll be less. It's not in the record what the taxes are today, Judge.
Was it
we
part of
believe
the-
it less because we believe we were getting overcharged by the Champion Volunteer Fire
Was it
Company.
part of this consideration of whether or not to split these into two districts the way you did? Were you considering the tax implication?
Absolutely, Your Honor, that the town board looked at what's the cost of fire districts versus fire protection districts, and typically the cost is about twice that. But that goes back to my point, Your Honor, of if I'm in fire protection district number 1, I'm only taxed now for fire protection in that district. And if I'm in fire protection 2, I'm only taxed for fire protection in fire protection district number 2. So I'm in a very different place than I was in 2014.
It seems to me part of the legislative intent here was to save taxpayer money, right, by dissolving government entities.
Exactly, Your Honor, by eliminating separate overlapping taxing authorities. And what appellant is saying is we were legally required by this statute to create the very type of situation the legislature said they were trying to eliminate.
Thank you,
Thank you.
counsel. Counsel, what about, is respondent correct when he argues that the will of the voters was not frustrated here because they got exactly what they voted for?
No, they never got, what the petition said was to dissolve and terminate the fire protection district. The primary question before this court is whether a fire protection district, whether it's 1 or 2, is still in the control of the town. The town is still in control. The residents did not want the town in control of setting taxes, in control of contracting.
But then why wasn't the request to create a fire district? Is he incorrect
power in
about
the
that,
law.
that you can't, can you request that? Is he
You-
correct?
Well, you can't request it as part of this process, and it's been a red herring. They've been arguing since day one. We've never once said what they have to create. What we are saying is you must dissolve and terminate the fire
You're
protection
basically
district.
saying there's not anything else they could create.
Oh, sure there are. There's a joint fire district, a fire
You're still
district,
talking about fire districts.
but there's 3 different versions of what
But
could
I'm
happen.
sorry, just to be clear again, and if I'm asking you to repeat yourself, my apologies.
Okay.
I just want to know, is he correct when he says that you do have an electoral process by which you can request, not you, obviously,
Yes.
the residents can request, the voters can request that the town form a fire district?
Request but not mandate is true. I think Town Law 171, I think, is where he's going. It's not part of this process. It's outside 17A.
Did the voters do that at any point in time?
No, they didn't need to because they have no authority to. It is, we agree, it is not up to the residents to demand what should exist after, but it is clearly the will of the legislature that what existed before cannot ever exist then. That's what the residents had the right to. And
Well, the residents now could seek dissolution of these 2 fire protection districts and request the formation of a fire district?
they-
Would they
they-
do that?
sure they could, and then we'll get 4, and then we'll get 6, and then we'll get 8, and then we'll get 100 different fire protection districts. Your Honor is right. That's what we're going to end up
Dissolve
with.
this and create a fire district. Can they
We
not
can't force
request
that.
that?
No.
I didn't say force that. I said, can you request that?
They could petition to dissolve under 17A, and then as a separate matter, they could request the fire district. Note
And then there would
today,
be public hearings on that?
there would be a public hearing, but there's no mandate that they follow it.
And then if what they did was irrational, is there any
No.
remedy for that?
No, as long as all the people in are benefited, all the people outside are benefited.
The town board elected officials?
Town board's elected
You
officials.
could vote them out.
You could, the supervisor's gone.
They're not following the will of the voters expressed through these various requests.
But the legislature gave the residents the right to petition as we're here when the government is unwilling and unable. And the legislative memo in support says that the legislature recognizes that a town board may be unwilling to accomplish dissolution. They have not accomplished dissolution. And we take note that they didn't even follow the process. 782 2I of the general municipal law requires that the plan of dissolution provide for the termination of the existence of the local government entity. Their plan of dissolution didn't plan for the termination of the existence. They planned for a word that matters. Division. That's all they planned for. So the appellate division was wrong. They never followed the process because they never planned for the dissolution. Even if you accept the Fourth Department's argument that all they had to do is follow a process despite the result, they never even followed the process.
Thank you, counsel.
Thank you.